did you have a trip out of the country somewhat recently?
We took the kids to Greece this summer, so that was fairly recent.
Had y'all been to Greece before?
Kelly and I had been for our 20th anniversary, but we kept telling the kids that once they learned how to eat more creatively, that we would take them to Greece. So it's really fun.
Good.
You got anything planned?
Actually, for the rest of the year, we don't, and I'm really excited about that. We had a pretty busy summer. Lots of, everybody who's getting married at my age right now seems to be doing an international wedding.
Really?
It's ridiculous.
You must know fancy people.
I don't know. I think these are just people who they themselves have been out working for a couple of years, and then all of their friends have kids, and they said, we want to leave the kids at home and do something else.
So it's like a destination wedding. You go, it's like adults only. You go to
Which is like, obviously it's fun, but Savannah and I talk about this all the time. It's like after the third or fourth one, you're just like, guys, this is like, can we just calm down a bit?
Just enjoy it, because I'm in a doldrums. I haven't gotten invited to a wedding in ages, because we went to a bunch of them, and then, now everybody's married. We're getting some divorces.
The divorce party is starting. That's really fun.
Yes, sir.
I have not argued here before. I have not. No, the clock is new to me. I'm going to reserve 5 minutes for rebuttal.
Until you're at 25 minutes, it's going to be going to cap in. At 25 or 5 minutes left, this is going to turn down. You know that you're in with the whole time.
Okay.
To that. And then one time, of course, you come up, you have your full 40 minutes, and once it's finished, there's come back up for the ball, but your time is starting. Whatever time you have left, stop the first.
Okay, so will it show 30 minutes and count down from that? And once I get into the 5-minute rebuttal.
Once you come up and say,
Okay.
please record this one time.
Gotcha.
Okay, and I say, go down to 5, and it's going to go keep going. But at 5 minutes, it's going to turn yellow, meaning that's your report time.
Okay.
So if you use 2 minutes of the report time, and at 3 minutes, it's time to get up to.
Gotcha.
Now, the judges, they control time. They need no time to take like less time. That's your time. Okay.
Sounds good.
Pretty much that's it. We want to make sure that everybody has your phones. If you have phones, if you have your sound or you turn it off, okay. Those young ladies sitting with you now. Everything is going to be recorded, both audibly and video. It's going to be on our website for YouTube. So if you want to come right now and watch it again. Whoever's sitting on this side, they're doing the same throughout the entire program. So, those are, yeah.
Thank you, sir. Thanks.
So I'll start recording in about 2 minutes before 2.
Okay.
All right.
I told her to bring him in here. Oh, did you pick her up with the gavel? Wouldn't it have been cute? See, we need to, we can put him up there. Yeah. Put him up there with the little gavel and then you can go. It's not there. That'd be fine.
Literally this one, we must have like.
Well, do anybody else bringing babies to court today?
Like I'm the only Hooverville judge that has an son.
The climate.
Excuse me.
Yes.
Trying not to make too much noise.
All rise. The Honorables, the presiding judge and judges of the North Carolina Court of Appeals. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Welcome to the Court of Appeals. It's good to see you all today on a beautiful fall day. I'm Judge Valerie Zachary. To my right is Judge Toby Hampson, and to my left is Judge Jefferson Griffin. To your right, well, we don't have our clerk of court with us today. We've got our deputy clerk, Roderick McFarland, and deputy marshal Richard Remillard. On the calendar this morning is Jarman et al. Versus Twiddy and Company of Duck et al. From Johnston County. Is counsel prepared? Would you like to reserve time for rebuttal?
5 minutes, please, Judge. May it please the court, good afternoon. My name is Dylan Castellino, and to my right is Tim Wilson. We are with Pointer Spruill, the Nash County Bar, and we represent the defendant and third-party plaintiff, Twiddy and Company of Duck, Inc. The issue on appeal is whether a forum selection clause contained within a vacation rental agreement applies to the claims of non-signatory plaintiffs who occupied the premises pursuant to the terms of that same agreement. By way of background, the premises is owned by Roger and Patricia Stricker. Those are also defendants and third-party plaintiffs in this case. Plaintiffs and their family rented the premises from Twiddy for a week-long vacation beginning June 1st, 2021 through June 8th, 2021. And plaintiffs and their family occupied the premises pursuant to the terms of a written vacation rental agreement. That vacation rental agreement contained a forum selection clause that provides, quote, any action relating to this agreement shall be instituted and prosecuted only in the Dare County Superior Court, North Carolina. The vacation rental agreement was executed by a representative of Twiddy and by the plaintiff, Thomas Jarman's mother, third-party defendant Georgia May. She initialed electronically each paragraph of the vacation rental agreement, including the paragraph 21 containing the forum selection clause. Although the plaintiffs did not sign the vacation rental agreement, they are still bound by the forum selection clause contained therein. And for that reason, Twiddy moved to change the venue of this action from Johnston County, where it was filed, to Dare County, pursuant to that clause. That motion was denied by the trial court, which is why we are here today. It's our position that plaintiffs are bound by the forum selection clause as third-party beneficiaries of the agreement and through the doctrine of equitable estoppel, and that the clause itself is broad enough in scope to encompass the plaintiff's claims at issue in this action. The trial court's order in this case should be reviewed for for a de novo standard and not an abuse of discretion, and here's why. So a party can move to change venue for two general reasons. The first is when the county designated in the summons and the complaint is not the proper one. In that case, the change is mandatory. That's NC Gen Stat 1-83 in the corresponding case law. The second general category is when the change would promote the convenience of the witnesses and the ends of justice. That's a discretionary decision. That is not what we're dealing with. We are under the first prong. So the plaintiffs filed this suit in Johnston County Superior Court under that default venue provision in 1-82, which essentially says you can file a suit wherever you reside at the beginning of the action. A contractual forum selection clause can change the default venue rule. And in this case, there's no dispute that we're dealing with a mandatory forum selection clause. It requires that litigation occur in a specific venue to the exclusion of others. there is no dispute that this clause is mandatory, and the dispute is over its application, whether it applies to the plaintiffs, and its scope, whether it applies to their claims. The issues are questions of law that depend on contract interpretation and the application of legal principles like the third-party beneficiary doctrine and the doctrine of equitable estoppel. If plaintiffs are bound by the clause and if it encompasses their claims, then venue in Johnston County is legally improper. It must be changed to Dare County.
So how do you respond to plaintiff's argument that a third-party beneficiary can enforce a contract against a party, but not the other way around?
I would point the court to the Harrison case that was discussed in our briefs, and also the McMillan case that followed. So in Harrison, that was actually a situation where a signatory was enforcing an arbitration clause successfully against a non-signatory. It's not a one-way street. And McMillan dealt with the same situation. I believe that was actually an operating agreement that was being enforced against a non-signatory plaintiff who didn't sign it, of course, but she was designated as an officer of the company within that agreement. And the business court found that she was a third-party beneficiary under that rule.
But one of the key issues in this case, though, is that, and I think what the trial court's order was getting to, is that we're not dealing with contractual claims specifically. It's not a breach of contract claim. It's not a claim to try and interpret the terms of the rental agreement, the contract. It's a tort claim. It's something that's outside the scope of the express terms of the contract, itself. So why would a mandatory venue clause that speaks to actions involving the agreement apply to completely separate claims for separate tort claims that do not necessarily arise out of the agreement?
And I want to join in his question. Basically, is it limited? Is that form selection clause limited to contractual claims?
What Judge Zachary means is she's trying to improve my question.
No.
So that question involves a couple of different aspects, and what I will say is it does not matter the characterization of the claim, whether it's in tort or in contract. All right. The reason that it encompasses the plaintiff's claims in this case is because those claims are necessarily dependent upon the plaintiff's status as lawful visitors and/or tenants. Okay? Their status as lawful visitors and/or tenants is born out of the vacation rental agreement. They acknowledge in their brief that the rental agreement permitted the use of the home by Georgia May's family, which is defined to include plaintiffs and their children. Plaintiffs were lawful visitors on the premises because, as Georgia May's family, the vacation rental agreement allowed them to be there. So some of those cases discussing estoppel talk about the entirety of a case hinging on the contractual relationship. This is a very similar situation. The entirety of their claims hinges on their status as lawful visitors, and they don't have a right to be lawfully on the premises but for the vacation rental agreement. Because the vacation rental agreement, again, it defines who's allowed on the premises to the exclusion of others. And in this case, it's Georgia May and her family. So I would not say that, given the fact that the claims are essentially tort actions, that's not indicative of whether they're encompassed within the forum selection clause. And the forum selection clause itself, as we've argued, is broadly worded. Any action relating to this agreement. Now, the court has certainly said that we're supposed to interpret contracts according to their plain language, and we look at dictionary definitions to decide what the plain language is. In Schwartz, that's exactly what the court did. Court did not look to Minnesota law to supply what the phrase relating to means. It looked in the dictionary. And in the dictionary, relating to just means some connection or relation. So if you take the fact that the foundation of these claims, their entire existence is dependent on the fact that they were allowed to be on the premises because of the agreement, and you couple that with the scope of the forum selection clause itself, there's no dispute that they should encompass, the vacation rental agreement should encompass these claims in the forum selection clause more particularly, which would necessitate a move to Dare County Superior Court.
And so when, but part of the issue here is not just on the relationship of the parties as, invitees, whatever, lawful guests, but the duty which they allege is owed here. And, the court, and the trial court seems to indicate that what it's relying on is the common law duty of any property owner in North Carolina to somebody lawfully on their property. The duty itself does not arise specifically out of the agreement here. How do you respond to that?
I would say that the duty owed to a lawful visitor on the premises and a tenant under the Vacation Rental Act does arise out of the vacation rental agreement itself, because again, it is by virtue of that agreement that the plaintiffs are lawful visitors and or tenants on the premises. So I understand the concern that the trial court had and probably styling these as tort claims rather than contract claims, but we submit that that's not necessarily determinative of the issues in this case. In fact, some of the cases that we cited to, including the Harrison case, if I'm not mistaken, deal with situations where tort claims are encompassed within arbitration clauses or forum selection clauses, even though they're styled as, statutory rights or common law rights. In fact, I believe that was the same thing in Schwartz as well. And it wasn't necessarily the relationship in terms of a contract right or a breach of contract to the employment agreement. In Schwartz, actually, the plaintiff's claims for libel and tortious interference, wrongful discharge, those were swept up in the forum selection clause as well, which again goes back to the point of its scope. So,
Does the vacation rental agreement refer to lawful visitors or lawful guests?
the vacation rental agreement under paragraph 4, and this is available in the record on page 68. Under paragraph 4, titled Use and Tenant Duties, the use of the premises is restricted to use by you and your family unless both parties agree in writing to occupancy by a non-family member group for a special event or for a special event, and neither one of those is at issue in this case. The term family, that starts on the fifth or sixth line down. The term family as used herein means parents, grandparents, children, extended family members vacationing at the premises.
So if you meet someone playing tennis, you can't invite them to come over and have lunch. Is that the gist of this contract?
That's the gist of this contract. I mean, it says who is and who is not allowed on the premises.
Is use defined?
It is not defined. I don't believe it is, Your Honor.
Okay. Thank you.
I jumped over this third-party beneficiary doctrine, but I do want to revisit that because I think that this whole conversation sort of highlights the point there too. So there's three elements to third-party beneficiary status. Only one of which is really in dispute here, and that's whether the third party is a direct or intended beneficiary under the contract. To make that determination, our courts consider the surrounding circumstances as well as the language in the contract itself. Now, this is an objective standard. It's not a subjective one, and simply because Georgia May, for example, might have said that I did not intend to confer this right of lawful use in the premises upon the plaintiffs. That doesn't matter. In fact, something similar was addressed in the Runnels case. That was one of the cases that dealt with the terms of a release. The release released all claims against all other persons, corporations, etc. And when a non-signatory to the release sought the benefit of that, the parties to the release actually said, oh, well, let me back up. We'll revise this release and show that we didn't actually intend it to do what the effect actually was. But the court said, no, we're going to look at the express language in the release itself, and it says that you agreed to release all claims. Well, that's what it is here. So as I mentioned, the vacation rental agreement, it gives the right of use in the premises to the plaintiffs as family members to the exclusion of others. That's not an incidental right. That's a direct benefit from this agreement. And it doesn't matter if the plaintiffs are not specifically identified by name. And think about the practical reality of that. Is you have these vacation rental homes with a dozen or so family members coming down to spend the week. It's just not practical to ask every single family member and within that group to individually sign these agreements. That's why it's defined the way that it is. Use is limited to you and your family. And I think that under the circumstances, it's reasonable to expect that each family member is not going to be identified in the agreement itself.
It goes back to Judge Zachary's question, though. What is use?
Certainly in this case, we would submit that use is occupancy, the right to be there during the week for the family vacation. Now, whether or not that extends further to meeting someone on a tennis court, I think that would be a more difficult question. I would argue that it's still use as you are using the home, you are there. But certainly in this case, there's no dispute that the plaintiffs had moved in the first day of the vacation with the intent to stay the week. And of course, while there's been some suggestion in the briefs that only Georgia May would be benefiting from this because she would essentially get the benefit of the plaintiff's company during the vacation home, I think it's certainly fair to say that the plaintiffs themselves would be benefiting as well by being in the home and using the premises that week. Unless the court has any further questions.
Well, actually, just kind of more procedurally, because the trial court's order here is more than just motion for request change of venue denied. There is it makes what it terms findings of fact and specific conclusions of law. Does that impact our standard of review? Like, what is the impact here of the trial court's findings? Or labeled findings and conclusions of law here on our review?
I don't think it does impact the standard of review because some of the findings, they're labeled findings, I think they're more appropriately conclusions. And that includes the finding or conclusion as to whether the signatories to the agreement intended to benefit the plaintiffs. We're talking about whether or not an agreement intended to benefit somebody else. I mean, that turns on contractual interpretation. Those are questions of law, right? I mean, those are really, that's not a matter of whether the evidence supports it. I mean, that's within the totality of the de novo review. And I would point to the same thing with respect to, let's see, paragraphs 21 and 22 and 23, whether or not they're seeking the benefit of the vacation rental agreement, whether or not the causes of action arise out of or relate to the agreement. I think those are all characterized, more appropriately characterized as conclusions of law. And just to be clear, we are certainly challenging those. And I hope that was evident within our brief in the discussion about the beneficiary doctrine and with respect to estoppel. And one last point that I will make too is the plaintiff has made an argument about how the scope of the agreement should really be interpreted to mean a strong or a significant connection or relation. Our position is, of course, is that really goes contrary to what the plain language says, which is any action relating to this agreement, relating to is some connection or relation. And that's a low bar to meet. The strong or significant connection, the genesis of that goes back maybe 3 or 4 cases from the federal courts and the Fourth Circuit. And initially, when this starts in the Sloan decision that was cited to in the plaintiff's brief, that clause said arising out of or relating to this agreement, and they borrowed a definition from American Recovery, which was very similar, arising out of or relating to this agreement. But even that case borrowed its interpretation from the J.J. Ryan's case, which is a Fourth Circuit decision, and the clause in that case said all disputes arising in connection with the present contract. And my point in saying all of this is that if we're recycling these definitions and we're applying them to different forum selection clauses, it just dilutes the value of the words that are used in the contract. So essentially, I don't think there's a reason for us to be interpreting the forum selection clause here, which says any action relating to this agreement, the same way that J.J. Ryan's interpreted the forum selection clause that said all disputes arising in connection with the present contract. Again, I mean, if we're looking at what the plain and unambiguous language of the contract says, then I would submit that let's rely on the dictionary definitions, which is what Schwartz did.
But your clients have control over the contract, over the terms of the contract.
Oh, of course.
That's right. And so, and typically in construing a contract, we construe, to the extent it is ambiguous, we construe that against the drafter, correct?
To the extent it is ambiguous. Of course, our position is that it's not ambiguous.
Right. Thank you.
Any further questions from the court?
Good.
No, thank you. You have 7 minutes and 49 seconds.
May it please the court, Matt Learberg and my colleague Andrew Sluckin here for the plaintiffs. I'm going to jump right into the standard of review. This order should be affirmed under any standard of review, whether it's de novo or abuse of discretion. But make no mistake, this is a decided issue in this court. So let's begin with Capital Bank versus Cameron. This is Judge Hunter opinion from 2013 that's cited in the briefs. In that case, Judge Hunter begins his analysis by saying that the standard of review is abuse of discretion, and then Judge Hunter says that the analysis begins with any unchallenged findings of fact. What the panel decides in that case is that the the movement seeking to change venue simply didn't come forward with enough evidence to show that venue was improper. That is exactly the framework that this court should apply. So in this case, the judge below had several findings of fact. The judge, it's in the transcript, invited the parties if they wanted to discuss further after the judge rendered his oral ruling. If anyone would like to stay and discuss these findings of fact, we can. The parties didn't. They kind of went home and exchanged proposed orders, and those proposed orders are in the record supplement. And interestingly enough, the plaintiffs had their own proposed order. Twiddy has their proposed order, but Twiddy did not object to several of those findings of fact, even below, let alone object to them on appeal. And there can be no dispute, a finding like that, that the plaintiffs didn't sign this agreement. That is a finding of fact. That is not a legal conclusion. The court found that the plaintiffs weren't aware of the agreement, didn't read the agreement. That's a finding of fact. That's binding on appeal. And because analyzing whether this forum selection clause applies to these non-signatories involves exactly these factual questions. Did they read it? Did they see it? That is why the standard is abuse of discretion with findings of fact upheld, provided they're supported by competent evidence. I looked through...
You would agree, even under an abuse of discretion standard, that if the trial court was acting under a misapprehension of the applicable law, that would itself constitute an abuse of discretion.
That's exactly right, Judge Hampson. There are always going to be, in any case, potential legal issues hiding in there that would always be reviewed de novo. And I looked at this case, and when reading through the briefs again, there's no objection from Twiddy's brief to the idea that findings of fact are binding on appeal. The word finding just doesn't even appear in the briefing. As for abuse of discretion, I think the only potential issue in the case that would be subject to de novo review would be the interpretation of the sentence in the vacation rental agreement that says any action relating to this agreement shall be instituted and prosecuted in Dare County. If the court were to interpret what that sentence means in a vacuum, that's probably de novo review. But applying that sentence, what does relating to mean in this context? What kinds of claims were these particular plaintiffs bringing? Were they aware of the vacation rental agreement? That immediately gets into the kinds of fact-specific analyses, which is exactly why this court has held since the mid-90s that forum selection clause disputes are subject to abuse of discretion standard of review, with, of course, these potential type issues where there's a legal issue or a legal interpretation at issue. But under any standard, the case law, I think, is clear that in this case, the trial court looked at these facts, the trial court analyzed the arguments that were being made, and found and concluded that venue was proper in Johnston County, and that these particular plaintiffs were not subject to the forum selection clause. I want to focus on, next, on the vacation rental agreement itself. So, if there had been no vacation rental agreement at all in this case, where would we be? We would be in a situation where the duties that were owed were just the standard common law duties or the standard duties under the Vacation Rental Act. And those duties are exactly the claims that these plaintiffs have brought. They very carefully, that complaint does not mention this contract. There are no claims under this contract. There are no claims arising under this contract.
Isn't that sort of part of the argument from your colleagues in this case? Is that through this language in the agreement of relating to this agreement, the concern is if we were to interpret this that narrowly, would it essentially open the door to these very carefully crafted complaints to say, well, we never mentioned the vacation rental agreement, therefore it doesn't relate, when in fact, if you're asserting claims under, the Vacation Rental Act or, various, warranties of whatever, duties that would otherwise be, a landlord to a tenant, for example, that, you're essentially just giving free rein just to be able to plead around the agreement.
Well, let's compare this to what if Georgia May, the actual signatory to the contract, had brought tort claims. That would be a different situation, right? I mean, whether that complaint mentions the vacation rental agreement or not, she did in fact sign it and did agree to be bound by the terms in that agreement. So that's a situation where, you know, artful pleading shouldn't be able to get around it. This is an entirely different situation, and the reason is that the default rule under the common law is that a visitor is owed certain duties, and visitors, as long as Georgia May has possession of the premises, she can invite anybody she wants. So setting aside this agreement, if this agreement weren't in existence, she could invite anyone she wants. She could invite somebody she meets playing tennis. She's in possession of it just like you are when you rent an apartment. Now, where does this agreement come in? This agreement is drafted by Twiddy, and it's their opportunity to limit, if they want to limit the common law default rule, which is that visitors are allowed, they are lawful by default. So they have that opportunity, and they do, right? I mean, there's in paragraph 4 and record page 68, Twiddy says, we don't want sororities and fraternities in the house. So they expressly have decided those are folks we don't want here, and if there were a sorority party there, then there could be a dispute, were they lawful visitors, and what standard of care is owed. But I want to be clear, one of the things that Twiddy says in their brief, there was a dispute in the briefs between the appellee's brief and the reply brief as to exactly what you and your mean in the vacation rental agreement. And what Twiddy says on their reply brief on page 6, they take us to task for trying to take a limited view of the word you, and they say, plaintiffs attempt to cabin the definitions in paragraph 17, that's of the vacation rental agreement, to matters of indemnity, but those definitions are operative throughout the agreement. The terms tenant, you, and your, as used in this agreement, shall include ... And so let's look at paragraph 17. Who are the you and your that are lawful visitors under this contract? In record page 70, at the last sentence of paragraph 17, Twiddy, in their own contract, wrote that the terms tenant, you, and your, as used in this agreement, shall include, and lists several people, heirs, successors, assigns, and then it says this, and other persons on the premises during your occupancy, without regard to whether such persons have authority under this agreement to be upon the premises. So under their own language, which needs to be construed against them, you and your is everybody. It is the entire universe of humans who might set foot on this property. So let's tie this and look at the third-party beneficiary and estoppel argument. It is Twiddy's argument, based on their reading of their own agreement, that everybody in the world is estopped from filing a lawsuit in another county. Everybody in the world is a intended third-party beneficiary of this contract. That is the natural outcome of their position, and that simply can't be right. And they're the masters of the contract. There's nothing stopping them from saying, if they don't want there to be, if they're worried about this kind of liability, they could say that Georgia May, and only Georgia May, is allowed to be on the property. They could, you can tell from looking at the agreement, if you look at record page 67, it's signed electronically months in advance, months before the week where the family is to be there. There's nothing stopping the Twiddies of the world from having the renter, having Georgia May list what other folks are going to be there for that week. Give us their email addresses, and they could send this agreement to them and have them sign off on it. It would be no more onerous than it was to send it to Georgia May. So the idea that it's just fundamentally impractical to try and engage in a contract relationship with someone who's going to be on the property for the week, there's nothing stopping them. They could do that if they wanted to, but they chose not to.
If you had brought contractual claims on behalf of your clients in this case, or claims very clearly and expressly arising out of the agreement, would venue be correct or mandated in Dare County?
No. And the reason is that for the forum selection clause to apply at all, my clients would have to be third-party beneficiaries of the agreement. So for Twiddy to prevail, they've got several hoops to jump through. First, they have to overcome the findings of fact at the trial court. Next, they have to overcome the idea that these particular plaintiffs never saw this agreement and didn't agree to be bound by it. And then finally, the last hurdle is, what does relating to the agreement mean? If they were able to get through all of those hurdles, then yes, Your Honor, in that hypothetical, they would be able to, I guess there'd be an interesting question as to whether some of the claims would proceed in one county and some would proceed in another. In fact, the trial judge kind of wrestled with that a little bit because of the presence of the third-party complaint here. There's a little bit of a discussion of that in the transcript from the hearing below.
Do you agree that your clients benefited from the vacation rental agreement?
No, they did not benefit from the vacation rental agreement. If the vacation rental agreement didn't exist, nothing would be different. I mean, they were lawful visitors. They were invited by Georgia May when she was in possession of the premises. Whether this agreement exists or not wouldn't change a thing about that week. But in any event, all of the claims here, the trial court found as a fact, looking at these claims, that none of them do arise under the agreement. None of them do relate to the agreement. They are all separate tort claims. I want to focus on the third-party beneficiaries question for a moment. The plaintiffs were able to find, it looks like, one case where a third-party beneficiary, a non-party, had the right to invoke the third-party beneficiary doctrine. And that's one case from this court. That's the LSB Financial Services versus Harrison from 2001. It provides a nice foil for the facts here. That's a case where, and the facts are somewhat confusing, but there's a dual employee situation where for the bank as plaintiff, for the bank to participate in securities trading at all, they needed to have this kind of three-way relationship with an entity called Uvest, as well as their securities employee, whose name is Harrison. So right out of the gate, there's a three-part relationship that everybody knows exists. So in that case, that's a fairly strong third-party beneficiary case where this tri-part relationship is part and parcel of the entire relationship from the start. This case is entirely different, right? Twiddy doesn't really care. By their own contract, they've decided not to care as to exactly who comes onto the property. So, what matters to them is that Georgia May pays the bill, and what matters to her is that she has the ability to be there. It is a bilateral contract that doesn't envision, again, the entire universe of people who fit into this definition of you who could possibly be lawful visitors. The same goes for the estoppel. It really rises and falls with the third-party beneficiary argument. The idea of estoppel is that Twiddy is arguing that no party like the plaintiffs can enjoy the benefits of this agreement without also encountering the burdens. But what benefit is it that they're seeking to enforce in this lawsuit? There's no benefit. In fact, there are very few, this is a fairly one-sided contract, there aren't that many benefits for anybody outside of Twiddy, other than the right for Georgia May to use the premises. Nowhere in the complaint, and not because of how it's pled, but just the reality of the claims they're seeking, nowhere in the pleadings are these plaintiffs seeking some benefit or some right that arises under these 4 or 5 pages. So without that, the estoppel argument fails as well. But I do think this case turns on this question of whether there are lawful visitors. Were these lawful visitors or not? And that is a common law question. You do not need to look at the vacation rental agreement to decide it. Lastly, I think it's important to think, what could Twiddy have done differently? If there's an entity like Twiddy that wants to protect itself, wants to do things differently, one is what we just discussed earlier. They could ask the signatory to the contract to provide a list of names of others who will be serving, who will be coming as guests, and send them these kind of easy click-through agreements to their email address as well. That's one way they could protect themselves. What else could they do? They could phrase their form selection clause differently. It wouldn't be sufficient, as a colloquy with Judge Hampson indicated earlier. It wouldn't be enough, but it could help. The idea of it saying just relating to, they could say what the party said in the big league business court case. They could phrase it as any dispute arising directly or indirectly from the relationship created or the transactions contemplated by this agreement. That would be better that would, go beyond just relating to this piece of paper and would get to the underlying relationships. It wouldn't be enough in this case, but it would help. That's something an entity like Twiddy out there could do to protect themselves. And lastly, it bears note that the Strickers did not notice appeal. So there were actually 2 motions below. All of the defendants had moved to transfer venue, but only one of the defendants sought this appeal. The Strickers, for whatever reason, decided that it was not worth it for them to notice appeal. So that's an indication kind of their interest in this case being transferred at this point.
But does that have any legal effect? If you've got, for instance, one co-defendant says all these claims have to be brought in one county, and another co-defendant, either hypothetically says, well, no, we're fine to proceed in this county, or we'd prefer to proceed in this county. I mean, where does it go in that instance?
And Judge Hampson, I think the reason it matters is that this is exactly the kind of thing that a trial court has to weigh. They have to weigh who wants the venue to be transferred and who doesn't. I mean, there are a couple of the cases that set forth.
But here the trial court had before it. The posture in the trial court was that all defendants had moved to transfer venue based on the venue selection clause.
That's right. And the reason I raise it now is to highlight one thing, which is that this was an evidence-based determination. So if, for example, take the third-party beneficiary. If Twiddy thought that there was any evidence that they had that the family members were intended third-party beneficiaries, they could have produced an affidavit from somebody that when they communicated with Georgia May, she said, I'm bringing my family. I mean, there's a potential world where there's evidence there, but they came forward with nothing. If you look on the record, the only evidence is the evidence that the plaintiffs put forward showing that it actually would be convenient for everybody except Twiddy, and in particular the other defendants, if the case were just tried in Johnston County. And there's maps and kind of calculations of how long it would take for everybody to get to the courthouse. That's the only evidence in the record. So the trial court weighed that and decided that to continue to leave venue in Johnston County. In the end, the plaintiff gets to select the forum for a lawsuit. That's the baseline rule, and that's been the rule for 100 years. So unless and until a defendant can come forward and show that they have a legal right before the trial court for the venue to be transferred, and then upon losing to show an appellate court that there was an abuse of discretion, the trial court's decision to allow the plaintiffs to have selected their forum should stand. If there are no further questions, thank you, Your Honor.
Thank you.
A few follow-up points, if I may. So plaintiff's position that if the vacation rental agreement doesn't exist, then nothing really changes. That's just not the case. So we talked about fraternities and sororities not being allowed on the premises. Well, if the vacation rental agreement didn't exist, then what's to keep fraternities and sororities from going onto the premises? It's the language of the agreement that decides who's allowed on the premises and who is not. So that certainly has an impact on their rights and the status of the parties in this case. And if you look to paragraph 1 of the complaint, which is in the record on page 5, I'm sorry, it's paragraph 9, the first paragraph on page 3 of the complaint. So on Saturday, June 1st, 2019, 2.5-year-old Gressy and his family arrived at home. Gressy's grandparents had rented for a fee from defendant Twiddy from June 1st to June 8th. the plaintiff's ingressee were lawful visitors and/or tenants at the home at all times relevant here too. So, again, our position is that the plaintiffs are certainly seeking to enforce a benefit that they have under the vacation rental agreement, more specifically, their status as lawful visitors and/or tenants. And to the extent that we're talking about artful pleading to avoid claims being captured within the scope of a forum selection clause, that paragraph is the perfect example of that. Acknowledging that the house was rented for a fee, but without acknowledging that there was a vacation rental agreement in place, acknowledging that they were lawful visitors and/or tenants, without acknowledging that the vacation rental agreement was in place. With respect to the challenged findings, there's no dispute that the plaintiffs did not sign this agreement. That's not a finding that's worth challenging, nor is it really determinative of the issues and what we're arguing about on appeal. The challenged findings are those conclusions that I mentioned earlier, which are set out in the order that talk about legal principles, whether someone intended to benefit, whether the vacation or rental agreement benefited the plaintiffs in this case. And in our brief, I mean, that's what the issues are focused on. That's what the arguments are focused on. So those are certainly challenged. And the fact that evidence is at issue, I believe there was some decision years ago that talked about an abuse of discretion standard applied in a completely different venue issue. And in that case, it was an appropriate standard of review for abuse of discretion because there were so many evidentiary facts, such a fact-specific inquiry. But simply because there's a fact-specific inquiry does not mean that it's automatically abuse of discretion. I mean, look at what a summary judgment standard is. Summary judgment is literally like, are there any issues of material fact? What's more fact-intensive than that? And of course, summary judgment's reviewed on de novo, on appeal.
Well, that kind of raises an interesting question. Are there any issues of fact here that would need to be potentially resolved by the trial court, or is your position that it's one way or the other issue of law? I mean, I guess put another way, are you advocating in any way for this to simply be vacated and remanded for further findings of fact or proceedings, or are there issues to be decided by a trial judge before they could reach a determination here?
No, I don't think there needs to be any sort of remand for additional findings. The findings in the order talk about the vacation home being owned by the Strickers.
So at this point, it's just a true issue of law from...
Correct.
Okay.
The issues that we're talking about, those are purely issues of law, Your Honor. And the other portion in reference to the tenants as used within the agreement, there was some back and forth about that in the briefs because no one is contending that trespassers have a lawful right to be on the premises. We're not dealing with that here at all. And that's not our interpretation of the contract. So when the context requires or permits, such as the case of a family member who is occupying the premises, then that family member would be considered a tenant under the terms of the vacation rental agreement. That was our point in the briefs, and I hope that that came through clearly. Unless the court has further questions from me.
No, we don't. Thank you.
Thank you very much.
That concludes oral argument in this matter. We'll take this matter under advisement. I want to thank counsel for your excellent arguments this morning, or this afternoon. Mr. McFarland, we may adjourn.
All rise. This session of the North Carolina Court of Appeals is now adjourned.
Thank you. Matt, great job. Good to see you.